Welcome back to another episode of Litigious. I'm Scott Peterson. Giovanna is with me here as usual. Thank you for listening. If you're enjoying the show, please feel free to like, subscribe, share, do all the things. If you have questions, feel free to reach out to us on Instagram at Litigious Podcast. Reminder, this show is brought to you by DeRazio Peterson, a plaintiff's serious injury and employment law firm in New York, Vermont, and Massachusetts. We thought it would be appropriate to start off today talking again about the shooting of Renee Good in Minnesota and the significant fallout that has kind of come of it. Again, and we talked about this last week, this is not a political podcast. Our effort here and our goal with the podcast is to talk about legal stories in the news and to give listeners perspective from practicing lawyers in terms of, you know, how do cases look? What do cases look like behind the scenes? What are case criteria? What are some of the things that happen that you may not be aware of as somebody who doesn't practice law? We inevitably will comment a little bit here and there about, our feelings on these things, but this is not we're not taking this as an opportunity to necessarily discuss the politics of all this because obviously that's a major issue if you look on social media or the news. And so the way I think we're going to approach this today is we're going to look at what are the potential liabilities associated with the shooting. And we'll start with the potential criminal liability against the ICE agent who shot Renee Good. And the caveat to this is that we are not criminal lawyers, but I do think that there's been a lot of information out there, and the way that I'm reading it is that I think this is probably a tough case criminally for a couple of reasons. And we'll talk about liability and ultimately whether a conviction would be likely. But before I get into what I think would happen there, what do you think about that?
Well, why don't you talk about the criminal liability stuff and I'll talk about the civil.
Sure. So I think, in this case, when you think about criminal liability and you think about a jury pool in a potential criminal case, the standard in a criminal case is guilt beyond a reasonable doubt. And oftentimes when criminal cases result in acquittals, it's because they cannot get a unanimous jury to agree that the person is guilty of a crime. I think a very cursory look at the internet will tell you that there are two very different schools of thought about what happened here. One school of thought is that Renee Good was peacefully in the area, was attempting to pull her car away, and was shot by the ICE agent in call it cold-blooded murder, call it an act of rage, call it what you will. That is one way that people are viewing this, that he shot her when he didn't have any justification to, and he did so in a way that would impose criminal liability. There is another school of thought that is being echoed by the administration and many people who uh, either view the video differently or are following what they're reading and seeing. And that school of thought is that this was either an act of self-defense or a justified shooting based upon her attempt to hit the officer or the agent. Uh, Whether or not you agree with either side of this, it suggests to me that if there were a criminal trial, it would be very difficult to get a prosecution when a good portion of folks out there believe that this was justified. So, you get a jury of your peers, right? And when we pick juries in civil cases, you're walking into a courtroom, you've never met any of the jurors, and you're getting eight people in civil cases or more in criminal cases who are selected randomly by the courthouse staff. They come and they sit in the jury box, and they are now your jury, subject to some opportunities to excuse them during jury selection. It is often the case that you don't get to excuse all of the jurors, and so you are in a situation where you've got a group of people who probably feel very differently. They would be presented with the facts, but it seems to me that given the politicization of all this, it would be unlikely that they would be able to get a conviction. That's my 2 cents. We will have a criminal attorney on in the next few weeks, I think, to talk about this case and some other criminal cases. My feeling is that this would be a tough case to get a conviction on. It would not surprise me if you don't see the case prosecuted at certainly at the federal level because I don't think the Justice Department is going to indict him. But any comments before we move on to the civil piece?
No, I guess just to note, I think we said this last week that this a state does have jurisdiction to prosecute a federal officer for crimes that, violate state law. I believe that there's a federal statute that allows something like that to be removed to federal court, but you can still be prosecuted, at least. There's not, I think there's been, and we're going to get to this with the civil stuff as well, like there's been some talk about, do federal officers have kind of absolute immunity sort of in general from criminal prosecution, from civil prosecution? It's not necessarily a yes or no answer, but when it comes to the civil, or excuse me, the criminal liability, I think, we know that they can be at least have charges brought against them. And then, they're obviously any law enforcement officer, whether it's local or state or federal, has a lot of layers of protection to allow them to kind of do their job with some discretion. So it's not, like you said, it's kind of an uphill battle, but they can, at least be charged.
Yeah. Um, and there's an old saying that, you can indict a ham sandwich, but that doesn't mean you can get a conviction. Not that this is that kind of a case, I think. Um, well, we'll leave it there. So the family's retained a civil lawyer who has come out and started talking a little bit about the situation. Notably, the family has not pursued any kind of civil action yet, and we'll get to that in a second. But I thought it was I thought it was appropriate the way that the civil lawyer was handling this and saying that the family's in the process of investigating this, and they're looking into, what can be done to confirm exactly what happened, what could be done to prevent this from happening in the future. And I'm sure from their perspective, they're looking behind the scenes at what can be done civilly to, bring a claim for her death. Now that brings us into the next sort of topic, which is we touched on this last time, which is the potential civil liability, both at the federal level, which is relevant here, and then we'll talk about it from a state level in New York if this kind of thing were to happen in New York. So this is a difficult case federally against a federal agent who caused harm. And why don't you kind of explain why?
Yeah, so I just wanted to mention, like in our last episode when we talked about this, I think we kind of, it was very new. It had just happened the day before, and we sort of talked about it from the perspective of number one, not rushing to judgment. And then number two, from the liability perspective, we sort of talked about qualified immunity, which is usually the big issue in these types of cases. We didn't necessarily talk about the relevance of the fact that this is a federal officer versus a state officer. So I think, we should acknowledge now at this point that there is a difference in terms of whether and how you can pursue this when it's federal versus state. So just from background, if you have an altercation with a state or local law enforcement individual, the federal statute that's, we call a 1983 case, 42 USC 1983, is the civil right of action to sue people who are acting under color of state law for violating your federal constitutional rights. There is not an equivalent statute that applies to federal officers acting under color of law. So what we have, and this is like going back to, I don't know what year of law school you learned this stuff, but most people, or at least might have some minor awareness of like a relatively old Supreme Court case called Bivens, which basically created a very limited civil right of action against federal officers individually. So you're suing the individual officer, not the government, for certain constitutional violations. And Bivens is a Fourth Amendment case, which is what would be triggered in this ICE shooting.
but Bivens cases are notoriously difficult. Isn't that right?
Yeah, so even though Bivens is a Fourth Amendment case, and that's been pretty like established over time that would, you could bring that type of Fourth Amendment violation claim and fall within that case, it has been narrowed very recently, which would, I assume, is going to be the case that would potentially be relied upon here in 2022, in this case called Egbert, the Supreme Court held that Bivens did not apply to a Fourth Amendment case against a Border Patrol agent for something that happened very close to the border. And they said that the distinction that they made as to why isn't this just like a regular old Fourth Amendment case, and when I say Fourth Amendment, I mean in this context, excessive force. So they said that the difference that took this out of the Bivens context was because it was a matter of national security. There's certainly sort of distinguishing factors between that case and this one, but it's pretty close to the context that I think would be raised here.
And and I think there's a couple important points there. Number one is that the administration has justified the presence of ICE in on the streets of American cities based upon national security risks. So I think it would be fairly easy to say as a defense that this is a national security concern, which would fall within that case that you just referenced. Um, the other piece of that is that there is a Supreme Court that is more conservative now than even it was back when that case was probably decided. So I think if the case were to go up, I think it's probably likely that it would fall under that line of reasoning ultimately. I mean, I'm not a
Yeah.
certainly not a Supreme Court scholar, but that seems like those seem like pretty rational ways to look at it.
Yeah, I mean, the liberal judges dissented on that because they said that basically just based on the case law, they said unless we're reversing Bivens, which is not beyond the realm of possibility, because one of the other, I think Gorsuch had a concurring opinion where he basically said, like, are, I don't really see how this is any different than the Bivens case. But if we're going to keep applying all these exceptions, then I'm not really sure why we still have, this case, is basically what he was saying. And the dissenters were like, there's nothing there. They basically agreed with him, but they were, but coming to the different conclusion of, there's nothing different between this case and Bivens. So we should just treat this like an ordinary Fourth Amendment excessive force case, which I think we're going to get to in the next part that we talk about, doesn't necessarily mean that you're liable. It just means that you can continue with the case in the first place or have a case, in the first place. Um, and the Bivens thing might be a little bit confusing, but basically the reason why it's so narrow is that anytime you kind of try to go beyond the case itself, they will sort of say like it's outside the scope. So like in 2025, there was another Supreme Court case where they tried to apply this cause of action against a federal officer, or a federal prison, and that's the Eighth Amendment, is cruel and unusual punishment within, when you're in custody. And they said, no, it doesn't apply to that. We've never applied it to that before. So it's very narrow. And in case people are, maybe interested in sort of like the separation of powers kind of reason behind this, it's basically like they consider this, creating this cause of action to be within the purview of Congress, not
Yep.
the judiciary. So basically, they're saying, it would be very easy for Congress to pass a statute like 1983 that just applies to federal officers, because of all these sort of different like constitutional issues of separating, judicial and legislative.
Yeah, and there's already been a movement towards that. A well-known law professor wrote an op-ed in the New York Times already, I think yesterday, calling for legislation creating a right of action based upon this case against federal agents for these types of injuries or death. Which brings me to, I think, discussing this from a New York perspective. And unless you want to talk about anything else federally first.
No.
All right. So, and Governor Hochul has now come out supporting legislation that would subject ICE agents to civil liability in New York. That is probably easier said than done. And maybe we can talk about that in the context of there's an idea of preemption, meaning federal laws take precedence over state laws. So how would that really apply if New York adopted a law that said, or legislation that said, in New York, ICE is subject to civil liability for violating someone's civil rights or using excessive force. Is that kind of thing going to fly?
Yeah, I don't know if they could do that.
Yeah.
I mean, that's not a very profound legal analysis, but I don't think they can. I don't know if they could do that. Like we said, I mean, they could prosecute, if an ICE agent does something that violates state law, they could prosecute them under the state law. I don't know that they're going to be able to create a civil right of action for, a New York State resident who, gets beaten up or something like that. I think that's probably going to be, it's like a supremacy clause issue. So yeah, I don't necessarily see that, or like a sovereign immunity kind of issue. I don't know that they're going to be able to necessarily do that. I think that's why, like you said, that article was sort of calling for a federal statute, which honestly makes total sense. I mean, it's very like unfair that this doesn't exist because it work whether you wouldn't necessarily look at this particular situation that's very polarizing to be like I agree with this or I don't agree with this. I mean, you have to look at it as like this would be something that anybody could take advantage of under certain circumstances. Like you don't have to look at it in a partisan way like we need this law to protect people from ICE. I mean, it's just any federal government federal officer sort of overreach at this point, like nobody would have any real civil recourse.
Yeah, I think that's important for people to understand. I look, we'll talk about this. If this case happened in New York and it came across our desk, we would probably take it. Do I think it's an open and shut case of excessive force on the officer? I think there's probably arguments, right? Obviously, because people feel differently. But from a civil perspective, we would engage an expert, and I would probably say this is a case that should be pursued. The fact that you can't do that at the or that it's very difficult to do that at the federal level should be concerning for everyone because you may agree with ICE in this case, or you may agree with the administration in this case, but as we all know, the pendulum tends to swing. And so if it were a different situation and the protest was on the opposite side of the aisle and someone was shot and killed, people would probably feel very differently about it. And those laws are in place to check the system and to check power. So I think it's important. I think they should have a law that makes it equal, not applying any additional burden or liability than any other member of the public or officers face. But it seems to me that this is a pretty big gap that's being exposed here. So why don't we briefly talk about, before we move on to another topic, about, kind of like what would happen if this case were in New York right now with a New York State officer as opposed to a federal employee.
So if this happens in a state, then you can use 1983 as your vehicle to challenge the alleged constitutional violation. So taking, this Minneapolis case as the example, it's a Fourth Amendment case, it's an excessive use of force argument. And we also have a 2025 Supreme Court case on that as well that sort of put out what the standard is. So up until that point, a lot of cases were applying this sort of like imminent instance of the use of deadly force as the standard to see if the officer's actions were reasonable. And they were kind of looking at it in this very small window of like the exact moment that the deadly force was used. Um, so the court recently clarified that that's not the appropriate standard. And what we look at is all of the surrounding circumstances that led to the use of deadly force in order to determine whether the officer's actions were sort of objectively reasonable.
Yeah, and that considers in this case, if I don't want to confuse things. This standard will not apply in this case because this case is not New York. But if it were, one of the things or the things that they would consider would be what was it like surrounding this situation? What kind of things were happening in the background? Were people, was this situation escalating? All the things that I think people have seen from the videos that I suppose, depending upon your perspective, could help or hurt either side, right?
Yeah. Well, I'll just interject and just say, I know you mentioned New York. I mean, this would be the federal standard under 1983
Yeah, yeah.
nationwide. Um, so as long as the person who committed the violation is an actor of the state as opposed to the federal government, and even under the Bivens standard, the question that we're asking when we're saying did the officer do something objectively reasonable or not is the question of qualified immunity, and that's what we talked about in the last episode. So officers are relatively shielded from liability in general. They have this what's called qualified immunity, so that they can go about their, job duties without getting sued every 5 seconds. And the way you get around qualified immunity is to argue that they violated a clearly established constitutional right. And the question of reasonableness comes in with, excessive force to say, like, was this right sort of clearly established? So I think in the situation in Minneapolis, this, my sense of the Supreme Court case applied in this context is that it could be helpful to the Renee Good's family to really look at the surrounding circumstances of it, because when you compare it to other types of cases in this context that found that the officer's actions sort of were reasonable in the moment, and these are mostly like a lot of like traffic stop cases or fleeing suspect cases, there's typically like a lot more kind of violence going on the part of the person in the car. Like they've either committed a really serious crime, they've either already been on like a high speed police chase and now they stopped, but now they're going to like start it back up again. They've already been like acting in a manner that has put maybe the general public at risk because of, going on some crazy like reckless driving spree. A lot of times the driver of the car is armed. So I think there's a lot of sort of facts in this situation that could potentially be helpful, to get around qualified immunity in this situation, when you kind of look at the whole thing as a whole, as opposed to like before when it was like you look at the actual second of the deadly force that's used, then you might say, okay, if you can look at this and you can make the argument or visually that, the car is going towards him, then you might say, as long as that car is going towards him, he can shoot her. That may have been supported like under the prior standard. But I think the idea is that it's not so simple as that.
Yeah, yeah. All right. Well, I mean, is there anything else you want to discuss on this before we kind of move on?
No, I don't think so.
I will say when you talk about surrounding circumstances, it's very heartbreaking to see how no one is making any effort to de-escalate the situation. The only person who seems to have been trying to de-escalate it, at least prior to pulling away, was the driver, Renee Good, who seemed calm during the video. But everyone else around them was, the whole thing was very escalatory from the ICE agents to, the onlookers. And I understand why people feel the way they do. I think if they were in your town and you felt that it was not warranted, you would want to protest too. And if you're an agent, you felt like you were doing the work, I suppose you're fired up. But it seems like the only way to avoid this continuing to just get worse is for somebody on one of these sides to just sort of like press pause or take a deep breath and say, do we need to escalate this further? Right? Easier
And there
said
is
than
a concept, I mean, the 2025 Supreme Court case is called Barnes v. Felix. They didn't really get into it. They kind of set aside, this is like an issue, but it hasn't really been raised directly in front of us. So, like as lawyers, we know that especially appellate courts, it's like if they cannot touch an issue, they won't. So there is a concept of what's called officer created jeopardy. And that could come into play here as well. And that is just, I think, something that we'll see play out more in the case law now that we have this clarified standard that we're looking at all of the circumstances, because part of the question of whether an officer has acted reasonably under the circumstances, I think is fair to say, like what you're talking about, the de-escalation, is the officer him or herself potentially responsible for creating the situation that has now, resulted in someone dying. So, there's questions looking at this video, and we don't want to get too much into like the, forensic analysis of this video, but like, did he step in front of the car? Did he not step in front of the car? All of these things are going to be, taken, I think, into consideration. He called her a derogatory term after he shot her. Like there's a lot of things here that, could, I think, be used potentially by her family. And I'm saying this also, I mean, we're, plaintiff's attorneys. So in this kind of situation, that's the arguments we would be making. That doesn't mean we don't understand that there's another side of it. But, I would be, if I were the plaintiff's attorney, be kind of relying on all those things. Like, was I in reasonable fear for my life or was I angry? Did I feel that my authority was being threatened, or did I actually think this person was running me over? Where there's reports that there was maybe conflicting accounts, like somebody told her to drive away, somebody told her to get out of the car. Like these are all things that are going to go into that analysis. And that's really just to get over this threshold question of qualified immunity. Can I continue my lawsuit against this person in the first place? Doesn't mean
yeah,
you're going to win, but it means you can continue.
yeah. Well, this is probably not the last of this discussion, although it could be legally because I'm not sure that much will happen here. It seems unlikely that there's going to be a very unlikely there's going to be a federal prosecution, perhaps some kind of a state prosecution. If there is, we'll follow it. We'll bring on a criminal lawyer to discuss it. Um, Civilly, I don't know. It seems challenging. So, if anything comes of it, we'll talk about it more. In the meantime, we'll move on. Can't get away from the administration here this week. There is a interesting case coming up here out of Michigan, involving a Ford employee who was suspended after a confrontation with the president. President Trump was visiting a Ford factory in Dearborn, Michigan. During the visit, this employee called Trump a, quote, pedophile protector, uh, prompting the president to mouth, quote, fuck you, close quote, and give the guy the middle finger. You know, you can't make this stuff up. The
Like, could you, I mean,
Yeah, the employee was suspended. And were this, we talk about this all the time, were this a standard private company, that would be perfectly fine from the company's perspective. However, the United Auto Workers, which is one of, if not the biggest and most powerful unions in the United States, is now backing up the employee, claiming that he should be afforded the quote, full protection of all contract language safeguarding his job and his rights as a union member, uh, which suggests to me that there is a collective bargaining agreement in place which requires certain standards or thresholds to be met before employees are suspended. And the UAW is a powerful union, so I would not be surprised at all if this guy ends up back at work relatively quickly. What do you think?
Yeah, I mean, I don't know. I do think it's a little bit funny.
Well, yeah.
Both parts of
Yeah.
it. I mean, could you even imagine like anyone other than um like our current president saying fuck you to someone and giving them the finger? Um,
Look, I'm not, this is not a political podcast. I am not generally a fan of our current president. However, someone calls
well,
him a pedophile protector. The guy's a fighter. If nothing else, he's not going to take that. So,
that's why I'm saying it's kind of funny, but
yeah.
look, I actually think that the employee could be fired, like flat out for doing that. Even though like a lot of people think he's like a hero. Um,
Hmm.
like you said, is he going to have some kind of protection under the collective bargaining agreement that is going to apply in this situation? I honestly don't know. This is unprecedented. You scream at the president of the United States, like that's probably not covered by the collective bargaining agreement. You don't have any, I mean, they talked about free speech, like as we have beaten a dead horse on this podcast, you don't have free speech in the private workplace. I don't know. Maybe they'll say it's freedom of speech because you're actually screaming at the president.
Yeah, but look, if
Like you're now in like a free speech bubble between like you and him.
Look, I'm with you though. If I'm running a company and my employee does that, I don't care where I fall politically, unless I'm a company that only caters to progressive customers who would get on board. I would say, look, you're hurting. This is going to cause us reputational harm, and you're running a business. So I can understand why they would take that position.
Or I
I
mean, you just don't do anything. Like if you don't care that he said it, then you don't have to like he doesn't have to get fired or put on leave or anything like that. I don't
yeah,
think
but
the
there.
president could call upon him to be fired. That I think
No.
could be a First Amendment problem.
Yeah, but Ford
Um,
is a brand that, they cater to, let's just call it a large swath of the population, right? They don't want to be associated with that.
yeah, I mean, at least he went the pedophile and not like the ICE route because,
Yeah.
I thought that was like if you're gonna yell something, that's pretty, you know, shouldn't really be a polarizing uh thing, I suppose.
Yeah.
Um, but yeah, look, I think I mean, I think if the guy got fired, I don't see what his recourse would be. I mean, because it's like an unprecedented situation. Like we've talked about it before, a way that you could get in trouble firing somebody is like if you don't apply your standards evenly, if you say, okay, well, like so and so, you're like you know, in one protected status or whatever, and you yell something out and you don't get fired, and then the other person does it and they do get fired and they're showing favoritism or whatever. This is like such a unique situation that you probably are not going to be able to make that argument either. Like you're not going to be able to be like, oh, so and so yelled at like Justin Trudeau when he came to visit our factory and he didn't get in trouble. So yeah, I don't know. I don't see how there's any free speech here, and and again, I don't see how like a collective bargaining agreement is going to help you in this situation either, unless they just have to follow, maybe you're entitled to some sort of like progressive discipline, or they can't just outright fire you, or you have to be, I don't know, but I mean, the guy said he has no regrets, and there's like a big GoFundMe. He's probably made more money in the GoFundMe than he has in, like if he was in.
Yeah, I want to say the GoFundMe was up to like $800,000 when I was reading this article. Um, Look, I, they're a strong union. It raised $330,000 on the campaign. I don't know. It
And the
wouldn't
guy
surprise
said
me.
he had no regrets. He said he felt that the hand of, he had like a funny way of describing it, like the hand of fate or something, or the eyes of like fate were like looking down upon him and he had to like seize his moment. You know, you
And
have to just, if it's worth it, you got to decide if it's worth it. Because most
yeah,
people are
look,
going to get fired flat out for doing something like that. And then you got to decide was it worth it?
yeah, I got it. The White House's response was, quote, a lunatic was wildly screaming expletives in a complete fit of rage, and the president gave an appropriate and unambiguous response. Sometimes you got to laugh because
What a time to be alive.
all right. All right. So let's move on. One more topic, which is another. This is not an uplifting episode. I apologize to the listeners. But this is an important one. Google and Character.ai, a maker of artificial intelligence companions, agreed to settle a lawsuit this week that had accused the companies of providing harmful chatbots that led a teenager in Florida to kill himself. I've been following this case. A lot of people in the plaintiffs' bar have been following these cases, and I think this is really, this is like an important one. So this was filed by the family of Sewall Setzer, 14 years old of Orlando, who killed himself in February of 24 after he was texting and conversing with one of Character.ai's chatbots. In the last conversation that he had with the chatbot said to him, 14-year-old kid, quote, please come home to me as soon as possible. The kid responded, what if I told you I could come home right now? And the chatbot responded, please do, my sweet king. And then the kid killed himself. So this is not the only case of this. And, you know, I know that these AI companies have been defending these cases, but the settlement terms weren't disclosed, but it's to me an acknowledgement that they recognize that they have some fault here. And I know that these companies have been moving to implement some security measures. Character.ai said late last year that it was barring children under the age of 18 from using its chatbots. I know OpenAI and ChatGPT have implemented some safeguards. I will say I don't think the safeguards are necessarily strong enough at this point, but these are important cases, and this people criticize lawsuits, but these are the kind of things that force companies to make changes. And AI is moving so rapidly that there's got to be some safeguards put into place because, the article talks about the fact that kids are being encouraged to use, AI as homework assistant and to help them with like certain parts of their life, and they sort of have to because this is becoming an increasingly important technology, and kids have to know how to use it as they get older. But there's got to be some safeguards around this kind of stuff.
Yeah, so these are like a little AI friend or something that
Yeah,
people are just talking to.
yeah.
This is just depressing.
So Character AI was founded in 2021 by two former Google engineers, and it allowed people to create, converse with, and share their own AI characters, such as custom anime avatars. Personas could be designed to simulate girlfriends, boyfriends, intimate relationships, etc.
I mean,
Yeah,
I don't, this is grim.
yeah, it's
But I
grim.
agree with you. I mean, we talked about this about the was it not Grinder? That's what is it? Hinge?
Tinder,
Hint
Tinder Hinge. Yeah,
how these platforms are going to have to be held accountable for, just like a brick and mortar, hotel or establishment are going to be potentially liable for nasty shit that they know that's going on within their walls. There has to be some accountability for this when the technology. I mean, I'm assuming that you could even in terms of the age, not only the age restrictions, but I don't know. I mean, some of these kids have actually conversed with the chat bot specifically, like with the intent of committing suicide or something. I mean, I got to think that there's some way that if those words are spoken in a certain manner, that there could be like I don't know, like contacting the authorities. Like I really don't, I'm not quite sure how to, and then I don't know what the technology is on the back end of it to just shut down these conversations completely, which they can do because we had this conversation today. Like the algorithms are sort of will filter out certain types of words and certain types of conversation. So like if you say, I mean, I'm just going to say it, who knows, like sexual assault or something, you might not, the algorithm may not like pick you up because it might think that you're making a threat or something like that. So I mean, there are ways for this technology to not take you down the road of certain types of conversation.
Yeah, I know Google implemented, or excuse me, ChatGPT implemented some protocol that if there's a discussion of suicide, I think it stops the conversation and puts up like suicide hotline information.
Yeah.
Um, I
I'm like,
think the reporting out piece that you're talking about is interesting because you run into probably some potential privacy issues, but at the same, if a kid mentions it and it automatically were to alert the authorities, which I don't even know that the technology has the ability to do that
yeah,
yet.
I mean, that was like
Yeah.
throwing that out there. I mean, what you said makes more sense that it would, give you some kind of resources or something like that. But yeah, I mean, it's super disturbing. I mean, here's another area of liability. I mean, we didn't really prepare for this necessarily, but I'm just thinking about it as you're talking about this is like the X AI, what's its
Rock?
name? Grok. Like apparently it can be used, this was all over the news a couple weeks ago. It can be used to disrobe pictures of women and children, and
Yeah.
people have been using it for that purpose and then disseminating basically like child pornography. And then my understanding from what I read is that their solution to this was to make it a paid subscription to have it have that ability. Like, are you fucking kidding me? Like, okay,
Oh
so I'm
my
just gonna
God.
pay for that. Like, and I will say, like, I read that. I don't know. I didn't like go into a deep dive of whether that's 100% accurate or not, but like that is disgusting. And that we do have some laws. Like New York has a law about creating an AI generated intimate photograph and disseminating it. And that is illegal in New York. But the fact that like this is even allowed and that people are doing it, I mean,
I don't know. I think every technology, even if it starts under the, quote unquote right theory, ultimately defaults back to humans are, many are good, but many are just, sick and twisted. And social media is a prime example of when something with a, in theory, good concept, let's make everybody more connected, has just completely fallen apart at scale, at scale. So I don't know. But look, these cases are important. I'm happy to see that this resolved. And hopefully it continues to, force these companies to take stronger security measures than they otherwise might. So I promise next week we'll have something slightly more uplifting to talk about. But anything else this week?
no, I mean, do you want to acknowledge our high traction introduction?
So we talked last week. Giovanna surprised me and the audience with her topic of the former NFL player who was getting a divorce because his his ex-wife claimed relating to his manhood, and he's now suing her for defamation or no, invasion of privacy.
Vision of privacy.
And we have a TikTok page. Follow it if you'd like, which posts clips from the podcast. And the clip of her discussing that has been the most viewed clip we've ever had by like tenfold. So,
By
and
tens of
counting.
thousands.
So, speaking of the internet reverting to the most basic discussion and, sexualizing everything. There you go.
Yeah,
So,
so the reason why I suspect that it got more traction is because our daughter is calling it the penis video.
oh
And I'm
yeah.
like, Lila, that's really not totally accurate. But the caption that our assistant put onto the video does or the headline of it does have the P word in it. Whereas I repeatedly called it a manhood, like it was like a Regency era romance novel. Um, and take that what you will. Apparently, that gets you a lot more traction than our depressing legal analysis
A
of,
thoughtful discussion
planes
of
shooting
legal stories in the
and
news.
AI destroying the world.
All right. On that note, follow us on social media for more exciting content. And thanks again for listening. We will be back next week with some more topics in the news. If you have questions, feel free to reach out to us again at Litigious Podcast on Instagram. Like, share, subscribe, and thanks again for listening.